Hello, it's Johnny McGriffin coming to you from Chicago. As usual, we got some fun stuff. First of all, we've got this idiot sit who used to always wear a suit. I haven't even seen it, but he got an attorney. I think he's come around. He used to wear a suit, but then you just say dumb stuff. It doesn't help. Then you're just a guy saying dumb stuff in a suit. But even before that, Zach shows me that I had this knucklehead on who was getting on Judge McNally's nerves in the last stream. It was fantastic. I recommend it. Go check it out. It says listen on the thumbnail. Anyway, this knucklehead is making Judge McNally crazy. Well, what I didn't know is that there was an hour prior to that we had to go around where instead of showing up to court, he was out in the court parking lot and zoomed in. So we're going to do that as an intro. Then we're going to have the subset who changed his mind. And then I got a slew of other good stuff. Let's do this thing, shall we?
Is Mr. Siak in here?
No.
Mr. Siak logged in, and we can explain that. He's in the parking lot on Zoom. He will come in if the court wants him to come in.
Yeah, but
We'll try to get him in, and he refused to come back in.
tell Mr. Siak to come in here. If he's not in here in 5 minutes, I'm going to issue a warrant for his arrest.
He's
I'll
on
do-
Zoom, Judge. I just brought him in.
Siak? Clark, Andrew Steven Siak, 25P7174451. Your name?
Andrew Stevens, I
Is Tucker Davis your name?
Don Tucker, P59229, Your Honor.
You're all on behalf of the people. There is nothing written on that file. The reason is because while we were sitting on there right before this hearing, the victim was here. Andrew Siak, the victim, did have contact the victim advocate here from our office. As did Will, the court officer. I spoke.
Mr. Siak, let's stop. I'm not
stop
gonna
what?
play-
I'm sorry.
I'm not going to play games with you. Either
Okay.
walk in here right now or I'm going to issue a warrant for your arrest, and it's going to be a really high bond. You got about
Why,
3
man?
Mr. Siak,
I
Mr.
arrest me and hold me in jail for a
Knock it
crime
off.
that
Knock it off.
Mr. Siak, I'm advising you to be quiet.
He's got 3 minutes to get into this courtroom or I'm issuing a warrant. I'm not going to play games with you hanging out in the parking lot.
you guys, I'm on the way
You
in.
got watch your mouth.
Yeah, I'm
You
on
come in
my
with a
way.
different attitude, or you're going to end up in the back one way or the other. I promise you.
Is it
knock
going to
it
be
off.
one way or other?
Shoot
I'm
him.
on the way in. I just,
Shoot him.
I'm on my way.
Joshua John, Mr. Siak. Joshua John Muniz.
Both in the Butler County District Court entitled State of Kansas versus Quentin Lawrence Height. It's case number 2025 TR 1215.
All right, this knucklehead, bottom right. I've got a bunch of prior appearances. I don't know where they are, but I got a bunch of prior appearances. He used to show up to court in a suit and like use big words, but not understand and not make any goddamn sense. He's been chilling in the can long enough that he realizes he needs an attorney, so he gets one.
And 2025 CR 261. Jared Regier appears on behalf of the state of Kansas and the Butler County Attorney's Office. William Peterson as defense counsel. Quentin
Martin,
Height
thank you,
appears
Megan.
from the Butler County Detention Facility Zoom location. Court will review. This matter last came before the court on October 21, 2025. At that time, a hearing was conducted primarily on discovery issues. The court made certain orders of turnover of reports and materials. The court granted no relief otherwise on the subpoena quash order that the court had earlier made. Court then proceeded to take up a request by the defendant to continue the jury trial, and that was granted. The case was reset for jury at December 10, 9 o'clock a.m., with a pretrial conference established December 3 at 4 o'clock p.m. that time, it was announced that the pretrial conference would also be in person. The court reaffirmed its bench warrant bond forfeiture no bond hold order due to the defendant's failure to appear previously. The defendant was placed in custody with a no bond hold. Court set a discovery compliance review hearing for today by Zoom, and the court, of course, contemplated the defendant would participate from the county jail. Subsequent to that hearing, apparently Mr. Peterson has been retained to represent this defendant in both cases. Is that correct, Mr. Peterson?
Yes, it is, Your Honor.
All right. Is there any progress to announce regarding case disposition?
Yes, Your Honor. There has been in my short time on this matter. I've had a couple of discussions with Mr. Regier, including a phone conversation yesterday in which we talked about previous plea discussions, and that my client did inquire about diversion eligibility here. Mr. Regier referred me to their rules, which my reading, I don't think there's anything in there that precludes an offer of diversion if Mr. Height applies, which he would like to do. Also, Mr. Regier did send over an offer in regards to resolving this matter that my client and I have discussed briefly, and I believe that it also has, well, it's something we discussed as being able to, it's amenable to my client, I should say. But again, the diversion option is something that he would like to also look into. So at this point, Your Honor, we're prepared to let the court, set aside any future or any discussion on discovery compliance or any further discussion on the motion to quash, and even take the matter off the trial calendar if the court's inclined to do so, and allow my client to decide which of these two routes he'd like to go.
All right. As previously announced, Mr. Peterson, I do have a pretrial conference set December 3rd at 4 o'clock. I could convert that to Zoom, but the court wouldn't want this case or these cases to fall off the calendar. If the defense is specifically requesting I take it off the jury trial docket, I will, but I would want to leave the pretrial conference setting if you're available. Mr. Peterson, your availability by Zoom, December 3 at 4 o'clock?
Yes. And my hesitation, Your Honor, I was going to request that in person because Zoom is not our favorite thing to do. And what I mean by that is I'm in Topeka. Mr. Height is down there. We've got to travel to be in the same room anyway. And for other reasons, we prefer a in-person hearing, which...
Well, Mr. Peterson, I tried to do that as an accommodation to you.
I appreciate that.
If you want an in-person hearing, I think that's how it was originally set.
Yes.
And the court can maintain that as an in-person. All right. December 3, 4 o'clock. Now, the court will essentially set it for a pretrial status hearing. And I can remove this case off of the jury trial calendar for the December 10th date at counsel's request. Is that what you're asking the court to do, Mr. Peterson, specifically?
Yes, Your Honor.
Very well. Court will make that order. All right. With our next court date set and the matters that have been announced, is there anything else that we need to address at this hearing, Mr. Peterson?
Your Honor, I did file a motion to set aside the forfeiture of the bond in both of these matters. And
Let me proceed further on that motion if you desire, Mr. Peterson.
Yes, I would like to be heard on that. As I stated in the motion, Your Honor, Mr. Height is asking the court to set those forfeitures aside. A couple things I would just add from the motion, and I think it did include Mr. Height doesn't have a lot of experience with the criminal justice system, and he did, as you're aware now, heed the warnings of the court to hire counsel, get some assistance. He's done that, and I think moreover spent the last couple of weeks in a lot of self-reflection and thought about
Yeah, he did. This is a special version of my client's a knucklehead argument. Of course, your client's a knucklehead. We know that. This attorney is excellent, by the way. I can tell immediately. He's doing everything you can do to clean it up from this point. Ricky respects him. Even Regier respects him. He's just a reasonable guy practicing, pounding away, doing his job. That's it. But him dancing into this, yeah, my client doesn't know a lot about this stuff, and he put a suit on, got full of himself, and I don't know. One thing led to another. He ended up spending a lot of time in jail. Yeah, we know, Attorney Peterson. We watched the whole train wreck.
How to handle these types of situations and how to handle this current situation, and he is. Like I said, taking steps to rectify this and make sure he's never put himself in this type of position again. I think that the court's forfeiture of the bond and him sitting in jail has shown Mr. Haidt the ways of, it's important to always adhere to the court's rules, adhere to procedure, and is asking the court to allow him an opportunity to show that he can do that. We have an in-person setting, engage in discussions. He's taken steps to rectify what the registration offenses, as I put in the motion, prior to being placed in custody. And again, back to his very limited contact with the court system and law enforcement previous to these two cases. I think Mr. Haidt is in a position where searching for a phrase, but learned his lesson is this kind of one that jumps out at me at this point. So he is asking the court to, in the interest of justice, and these they're misdemeanors. He's aware of what he's accused with and the very serious nature of interference with law enforcement, and but he'd like an opportunity to show the court that he can do this without move forward without being in custody and resolve these matters.
Very well, Mr. Peterson. I am familiar with the contents of your motion to set aside bond forfeiture previously filed. Mr. Regier, on behalf of your office, what is your position regarding this request?
Your Honor, with all due respect to the court and counsel, the state's position is the court's prior orders should be maintained. These are two cases where the court found the defendant disregarded the orders of the court and failed to appear for a critical in-person motions hearing on October 2nd, which the state does consider troubling, especially since the defendant filed multiple demands for in-person hearings in both.
I love it. Pound sand, fake attorney. I don't care. Sit in jail. I like your new attorney. He's lovely. He's a nice guy, and I professionally respect him. But you sit in jail.
Cases in July. It would appear that between the October 2nd and the October 21st setting, rather than submitting himself to the authority of law enforcement, the defendant filed 3 separate motions in each case, 6 total in the aggregate. And it is the state's understanding that it was only through extraordinary measures taken by third parties that the defendant successfully appeared in court during the October 21st hearing. The state further understands that this court heard argument on the issue of bond at the October 21st hearing, and it would appear that the arguments raised by counsel for the defense in the motion are largely similar, if not identical, to the same arguments raised at that setting. And at that setting, the court did find that a cash or professional surety bond was not appropriate in either of these cases. Based on the procedural history of these cases, it does appear that this is a defendant who's able to file a number of motions and subpoenas and to retain private counsel, but not to appear in court when ordered. And the state is not aware of any new information which might reasonably justify the modification of the court's prior orders. So the state's position is the court's prior order should be maintained.
Mr. Regier, you make some good points and you articulate your position well. However, I think there has been one material change in the status of this case, which this court should take into account, and that is counsel's involvement, which was not present previously, which in the view of the court would help to cut down any of the what the court would deem communication issues that we've experienced in the past regarding Mr. Haidt and his cases. But before the court makes a ruling in this case, Mr. Peterson, the court has several conditions it would impose. Number one, I want a statement on the record right now from Mr. Height as to where he will be residing. And I don't want a P.O. box. I want an actual street address where he is representing to this court is his residential address.
The address that is on my driver's license is current. I do have a question. This is
All
being
right, Mr. Height, let me back up a minute. I hope you're just not playing word games. I want to know where you're actually going to be staying. I don't care what's on your driver's license. I want to know where you're actually going to be sleeping at night, where you're going to reside. Is that the actual residence where you live?
Yes, it is.
All right. Fair enough. You've been asked a question by the court. You have one for the court, Mr. Height. Be careful.
I was just going to raise a concern about the live streaming and of me putting my address out onto the internet. That was all.
I understand your concern, Mr. Height. I trust anyone who is familiar with the internet could probably locate that address if they wanted. All right.
Yeah, that's a fair concern, and you handled it well. The address on my address is current, and that's where I live. You had to pull some teeth to get that, but still, that's fine. And you're smart to not announce your address on the internet.
The second requirement, Mr. Peterson, and it's a simple one, and that is this court would require as a condition of bond or your agreement, Mr. Peterson, as counsel in the case, to confirm in writing after each court appearance the date, time, and location of Mr. Height's next appearance and confirm that with your client in writing. I would need that commitment from you.
Absolutely, Your Honor. Standard of practice.
Indeed. Indeed, it should be. You'd be surprised, however, Mr. Peterson, how many attorneys these days do not do that.
I understand.
Thank you for that commitment, counsel. I'm satisfied. I think that some of the problems we've had in the past have been adequately addressed by what we've talked about today. This court at this time will, at this time, reinstate the cash bond in each of these two cases, set aside any particular order of forfeiture that might lead to judgment on bond. You're back on bond, cash bond in both cases, Mr. Height. I will order your immediate release on these two cases. If for some reason you have other holds that we haven't discussed here, I'm not releasing you from those. But in regards to the two cases currently before the court, I'm going to reinstate bonds on both with the conditions and matters that we've discussed here in this hearing. Any questions about that, Mr. Height?
Not at this time.
All right. We have another court date set, December 3 at 4 o'clock. The court's ordering Mr. Height, as a condition of bond, of course, to appear at that time, Courtroom B, Butler County Judicial Center, for further proceedings in the case, which will be conducted as an in-person proceeding. All right, Mr. Peterson, with those rulings made, which I will expect you to promptly document through order, is there anything else from your perspective that we need to address at this time?
No, Your Honor, that has covered everything I have.
I think there's been certainly some discussion here about some matters being resolved by more or less agreement. I would hope that that will be moved on quickly so that there can be an appropriate announcement made on December 3, at least regarding the progress of those matters.
Absolutely.
All right. Thank you, Mr. Peterson. Mr. Regier, anything further that we need to address currently?
Not from the state's perspective, Your Honor.
Very well. I trust that there is someone from the detention facility who is hearing the court's orders and the order of release.
Yes, Your Honor.
All right. Essentially, it's reinstating of the prior cash bonds in the matter and releasing the no bond hold that was previously put on him by this court. All right. Thank you. I appreciate your involvement as well. If there's nothing further, then the Quentin Lawrence Height matter, or both cases, will be in recess at this time, and this meeting may be ended for all.
Oh, I hope he gets mad. I hope they get in a fight and he fires his attorney. His attorney's good. His attorney's just a straightforward, reasonable guy doing good things, making smart decisions and all that sort of stuff. Regier is Regier. Regier's no mercy. He just doesn't care. And I even liked Ricky's ruling. Ricky's like, Regier does his whole spiel. And Ricky's like, honestly, all that's right. I'm not, my ruling does not indicate that I think that you're full of crap, Regier. I'm going the other way because I'm happy that this attorney's involved and I think we can make a lot of progress. But having said that, none of the arguments you made were wrong. Absolutely none of them. Don't be confused. And that's exactly what happened. Just a lot of progress happened, whereas everything was just delay and nonsense prior to this.
Your name,
Yes.
sir?
Adam Reichert.
All right.
Are you my judge that I had for jury duty?
Nope.
Okay. I'm just now coming back, sir. I hear I wouldn't talk to you yesterday or something.
Well, I don't know.
I don't either, sir. So
I'm here because you have 2 charges filed against you, and I'm here to read you your rights and set your bonds and see what we can do about getting you out of jail.
yes, sir.
I'm Harris Blanchett. I am just the magistrate that's taking care of the jail tonight.
Yes, sir. I appreciate it.
And you pronounce your last name Reichard?
Yes, sir. Reichard. Reichard.
Okay, Mr. Reichard.
Yes,
You're
sir.
charged with cruelty to a non-livestock animal. Do you understand?
That's my dog, right?
Yes, sir.
Yes, I remember now, Your Honor.
Okay.
I don't know.
I'm not here to try your case.
Yes,
I'm
sir.
here to make sure you understand what you're charged with.
Yes, sir, I do. And,
Well,
and I hit my dad too, right?
And that's the next charge for hitting
Yes,
your
sir.
dad. So let's take care of these one at a time, okay?
Okay. I would never hurt my dog, sir. I don't know where I was.
Well, let's talk about that in a second, okay?
Yes, sir.
So let me tell you what your rights are so you'll understand what you need to do.
Okay.
You have the right to hire an attorney to represent you. You have the right to have the attorney present prior to or during any interview with or questioning by peace officers or attorneys that represent the state of Texas.
Yes, sir.
You have the right to remain silent.
Yes, sir.
You are not required to make a statement, but any statement you make can be used in court.
Of
You
course.
have the right to stop any interview or questioning at any time. And do you understand these rights?
I do now, sir. I do need a lawyer, though. Can I get a court-appointed lawyer?
Yes, sir. No problem. I'll put this down. The jail staff will assist you in completing the paperwork.
Yes, sir.
And are you a citizen of the United States?
Absolutely, sir.
Are you currently out on bond for any other charges anywhere else?
I honestly don't think so, but I don't. I just woke up, Your Honor. I've been gone for days. I'm bipolar and schizophrenic, and I was off my meds. And
Well, let me ask you a question. I'm gonna set your bond for cruelty to animals at $1,000. Okay, that's just the bond you need to make to get out. You understand?
can I get a bail bondsman or something?
Oh, yes, sir. You can hire your bail bondsman to get you out. Okay.
I don't fully understand the process, no, sir. But
Hang on just a second. Now let's take care of this second charge, and
yes,
then
sir.
we'll discuss the process. So the second charge, you are filed on for injury to an elderly person with the intent to do bodily injury. That's a felony in the 3rd degree.
Absolutely, sir. And I cannot afford that. I'm a U.S. citizen. I'm a gun owner. I'm a gun lover. And I can't be a felon, Your Honor. I wasn't there. My dad's always put his hands on me because he doesn't know what to do with me. And I was naked through the house and I was standing there in front of my dad and my dad's like, go put some clothes on. I'm like, what are you talking about? And he came up to me and he grabbed me and he was shaking. And I said, hey, get your hands off of me. And I stepped back and I just swung at him. But I would never disrespect my father, Your Honor.
Do you live with your dad?
I do, unfortunately. I'm disabled. I am mentally disabled. And I've been gone for no telling how.
If he's mentally disabled, how does he have access to firearms?
Long. They told me in here that I've been out of it for 3 or 4 days. And I said, what about the judge? And they said, you wouldn't talk to the judge. So I apologize to you. I was not there, Your Honor. I really need my medications and I will gladly do my time, but I need help, Your Honor. I would never hurt my dog, sir. But I remember doing it now.
Okay. Well, the rights that I read you still apply the same rights for hitting your dog,
Yes, sir.
except for one more right because of a felony, and that's the right to an examining trial. An examining trial is an opportunity for you or your attorney to look and see exactly what it was that the state has evidence against you.
Yes, sir.
And
I completely understand, sir, and I apologize, but and I'm glad to be here. I'm glad they put me in the padded room for however long it's been. And so thank you for taking care of me.
well, I'm gonna set your bond at $5,000 for the striking your dad,
Yes, sir.
and maybe we can get you some help.
Absolutely, sir. That's all I need. I would never harm my dog.
You keep saying that about your dog, but you don't say that about your dad.
Well, I never disrespect my father either, sir.
Well, that would be debatable as far as the action you took against him.
I completely understand.
All
And
right.
yes, I do need a lawyer, Your Honor.
Okay, well, I got you down for the lawyer.
Okay, great.
All right. Thank
I
you.
appreciate your time.
All right, sir.
Zach sent all this stuff over. I just have one hit after another. It's beautiful.
I'm still not finished.
This last call, Wing Tech TMAF 025G. Please unmute and state your name.
I think it's me. I was trying to unmute. That's what's up in the corner on my phone.
It is you. Can you state your name, please?
Labetta League.
League?
Yes, ma'am.
Labetta.
LAVETTA.
Gotcha. All right. Ms. League, you have 3 cases pending.
Yes.
You have a failure to maintain financial responsibility from 2018, a failure to display a driver's license from 2018, and a failure to appear from October of 2018. And you, in May of this year, you entered pleas of no contest to these charges and requested deferred disposition probation. And it looks like we set you up to do some community service hours, a total of 78 hours.
Mm-hmm.
And looks like you've turned in 15 hours. And then we don't have anything more from you. So we show that you owe a balance of $939. Can you tell me what is the status here? Why?
When I came down there to try to get this taken care of. In fact, I had asked for payment plans.
Uh-huh.
I was told that to do that, I had to show medical reasons why I couldn't do community service. I do have a lot of medical problems, and I didn't have that. And so I had to do the community service, and I was unable to complete it. I just couldn't do it. I tried. And I didn't know what else to do. I
Okay,
can't.
I think there was a little bit of a confusion. I think looking at my court clerk's notes, she didn't think you were asking for a payment plan. She thought you were just asking to be excused, to not have to do community service and not pay anything.
No.
Okay.
So I knew I was at fault. I mean, my insurance back then, I'd assumed that they would have just renewed my policy, but they didn't. I've had insurance ever since. I actually went to court in Pantego and I showed them proof and that I've had it ever since. I was only like a couple of days in the rears with no insurance on the vehicle because they didn't renew my policy. I have had it since then and I still have it. And I get that means it's my fault because I didn't know it had expired. My wallet was stolen and I did not have an ID on me, but I gave him everything for.
Yeah. Yeah, your policy wasn't in effect at the time. So you didn't have it. And it's your fault. Correct.
For me.
Mm-hmm.
And I didn't know what else to do, but I did try the community service and I just couldn't do it. I mean, it's so bad it embarrasses me to say that the last day I worked, I was hurting so bad that I wet myself and I just couldn't do it anymore.
Well, I'm very sorry that that happened, and I'm sorry about the miscommunication. My court clerk thought the notes here do not indicate they understood you were asking for a payment plan. You can do a payment plan. Can you make payments of $50 every 2 weeks?
I can't do it every 2 weeks. I make $900 and something through Social Security. My rent is $1,200. My son helps me out
So you don't make anything.
where he can. I can make payments, but I can't do it every 2 weeks. I can do it like once a month, but I can do. Is there any way I can do that?
Yes, ma'am. Give me just a minute, okay?
Okay. Yes.
I mean, can't we just do some accommodation on the community service? That's what needs to happen here. I'm skeptical, but whatever. She might have a lot of medical conditions. Maybe that's the case. It's not. It's more for the point of letting them feel like they're contributing. That's the sort of idea behind this. There's a component that's restorative here. I don't get into it, but that's what's going on, and it's more important than the freaking money. So you can do things that I mean, you can do really basic things. We're not sending people out to like a marine obstacle course to do that sort of work. And there's not only one option available. This is bothering me. She doesn't have any money. Make her work it off. It's better for her. It's better for society. It's better for everybody involved.
Ma'am.
I'm looking at all the notations here. All right. Give me just a moment here. I'm looking at the paperwork.
Yes, ma'am.
All right. So we're going to set you up for payments of $50 every month. All right.
Yes, ma'am.
Okay. And can you get those paid by the 5th of every month?
Yes, ma'am.
Okay.
Yeah, chain gang would probably be good. That'll toughen her up. We'll put her on a chain gang with some real thugs. They don't care if she wets herself. I'm kidding. We can find something more reasonable for her.
So let's have you start on, I'm not going to have you start tomorrow since we're just ordering it today, starting on December 5th. All right.
Okay.
Okay. Now you can always pay more than that if you want to. Just don't pay. If you pay more than that 1 month, that doesn't mean you miss the next month. All right.
Right.
All right. So you just need to sign it. You can take a picture of it or bring it in, whatever works best. All right.
Yes, ma'am.
Okay. Any questions?
No, ma'am. Thank you very much.
You're welcome. This concludes.
Is that going to be on my record, the no insurance? Because, like I said, I have had it the entire time.
No, as long as you go ahead and get this paid, it will eventually be dismissed. All right.
Yes, ma'am.
Okay. All right. This
Thank
concludes your hearing. You're released at this time.
Thank you.
Good luck to you.
Bye-bye.
Next, I have Mark Hickson.
I love it. That right there is some legitimate Zach editing for you all. Sometimes people get confused and think I'm involved with that. Makes me look good, but it's not true.
Mr. Hickson, there we go. Mr. Hickson, I show that you have 2 charges, high grass weed violation and rubbish or brush in an unsanitary condition. Do you understand you are facing those 2 citations?
Yes, ma'am.
Okay. Were you able to hear my earlier explanation about defendant's rights and options?
Oh, yes, ma'am.
Do you have any questions about those rights and options?
No.
Okay, I need to take your plea to each charge. To the high grass weed violation, how do you wish to plead? Guilty, no contest, or not guilty?
Deferred adjudication.
Okay, so you pleading no contest to the high grass, and to the brush violation, how do you wish to plead?
No contest.
Okay.
Deferred adjudication.
Okay, I need a couple more things we've got to go through before we get to the deferred request. And you wish to waive your right to jury trial and me hear your case, correct?
Yes.
And you wish to represent yourself, correct?
Yes, ma'am.
Okay, and you're
No one's going to say anything about this oversized polo? Okay.
requesting deferred disposition, correct?
Yes, ma'am.
All right, do you have any other information you want me to consider before I render judgment?
Yes, ma'am.
Go ahead.
Okay, so this is a rental property that's owned by a corporation. I do own the corporation. I wasn't notified that this condition existed. I own lots of property. This is a very unusual way that they would deal with this, in my opinion. When I was notified of that
I don't know how to put this, but I'm kind of a big deal.
I got a ticket. I got it taken care of. I don't know why my staff let me down on this, but it happened. So I just would like you to take that into consideration. It's all in the same thing, but we have a tenant in the property, and we're living the happy life.
Was it vacant when this condition developed?
Yes, the tenant was just moving in at this time. According to my manager, he told me that the person that he hired to mow the yard and haul off the brush that
yeah, that vibe can happen. I actually really do have some sympathy for this guy. He's a landlord. He's got a tenant going in there. It's not something he's thinking about daily. I mean, maybe it's a violation. Maybe you should take care of it. I'm not saying that, but it's not like hardcore criminal intent sort of stuff.
Didn't do it because of weather. There's all kinds of excuses that we deal with all the time. I mean, I don't want to minimize it. I'm not trying to be I live in Dalworthington Gardens, and I'm certainly not trying to do anything to offend the city.
Okay. Okay. And I'm just curious, do you have a system now for someone to check on the properties somewhat regularly to make sure that they're in compliance?
Well, the tenant is responsible for grass
Mhm.
when it's occupied. We were responsible at the time. My manager does
You say that like it's a bad thing.
spot check the properties. We own a couple on the street. So
Okay. Okay.
we don't want to be bad citizens.
Okay. All right. I appreciate that. And it has been rectified. Is that correct?
Oh yeah.
Okay. Very good. All right. Anything else you wish me to take into consideration?
No, ma'am.
All right. And you're requesting deferred on both of these, correct?
Yes, ma'am.
Okay. Based upon your pleas of no contest, I'm making a finding on the record that there would be enough evidence to find you guilty, but I will not find you guilty. Instead, I will defer finding you guilty and I'll place you on deferred disposition probation out of this court for 90 days. Deferral fee in each case will be $150. Court costs are $81. Will you be able to get this paid in full by Monday, or do you need some time to pay it out?
Oh, ma'am, I'm going to get it paid right now.
Well, give us a minute because we're here in court and all the paperwork's here. So give us at least till after lunch, okay?
Hey, can I ask a question for
Go
you,
ahead.
man?
Yes.
Could you tell me who the woman was and how much she owes? The woman who wet herself on the thing. I want to pay her fine.
When you come up, you can ask and we can let you know. I don't want to say that here again, okay? But when you come up,
Would you put a note on the thing? Because
Yes.
I just like to pay. I just want to do a good deed for this lady. I mean,
Yeah, take that for all you landlord haters. And that's typical. People who have things are charitable very often. Suck it, socialists.
You bet. We've got it. We've already made a notation, okay?
Okay,
Go
thank you so
Mark.
much.
Thank you. All right. You are free to go at this time.
Thank you very much.
All right, good luck, sir. You had a question?
How does one become a confidential informant?
Well, I don't want to talk about that on the live feed. I don't know the answer to that. You can send a kite out to Chief.
Somebody left this on my Discord. I can't remember right now. Thank you. This is so fun. How do I become a confidential informant? He asked the judge on the YouTube channel. Middleton's flabbergasted. Let me back this up to 10 seconds because I stepped on it.
You had a question?
How does one become a confidential informant?
Well, I don't want to talk about that on the live feed. I don't know the answer to that. You can send a kite out to Chief Deputy Zuck. But
Gotcha.
all right, I'll just leave that at that. All right.
Thank you, Zach, and thank you, Mike Sweet.
He just announced to everybody at Sturgis that he wants to be a confidential informant. Okay, that finishes our morning.
All right, sir. Can you state your name, please?
Anthony Lee Crawford.
All right, Mr. Crawford. Do you have a residence yet?
I don't know. They just kept coming from Zach. I was putting together a stream and then he sent me another one. I threw this on the back. It's got to be good.
There's a problem with that, but no, I'd like to explain that if it's okay with you.
How about a phone number to contact you with?
I like the warming shelter if I be released to go to warming
Okay.
shelter.
All right. So you're in custody on two different cases, 2025 CM 12240 and 2025 CM 12251. We are waiting for the evaluation to be completed on you. Received a motion from your attorney requesting that you be released out of custody. So your attorney's requesting that. The prosecutor has reviewed that and has not objected to it. So what I'm going to do is send an order to release you out of custody and give you a new court date of December 15th at 9:30 a.m. for your pre-trial conference on those cases. So you still got to come to court and meet with your attorney on that date and time. Do you promise to do that?
Yeah, from here?
Yeah, so I'll release you out of custody and then give you a new court date and you'll get a copy of this. Here's your conditions of release. Obey all orders of the court. Do not commit any crimes. Notify the court immediately if you obtain an address. Do not contact any of the alleged victims. Do not go near any of the alleged offenses, locations. Do you understand those release conditions?
Yeah, may I ask a question?
Yes.
How I go asking a jurisdiction question without structured justice trespassing question?
Can you step forward a little bit and speak up? I'm having a hard time hearing. Go ahead.
How do I ask you a jurisdiction question without trespassing, a structured justice question?
Well, I can't give you legal advice, so you can ask your question and I can see if I can answer it for you.
I have a record all over America.
Okay.
From prostitution, misdemeanor and felonies, from being domination manipulated by human trafficking type of way that is by gang activity.
Okay.
When I was forced out of resources places because they have the right to say no. And I did not have the understanding between the gap between what they said and patience.
Okay.
And it wasn't a patience issue, it was the fact that I wasn't giving the information, which like case managers, I tried to be independent about that and contact myself about the ID, birth certificate, social security card.
What the hell are you on about? I wasn't ready for this. I was not ready. I just walked into this blind like y'all. All right. This is what happens. This is a live event here.
To get job services. Please think that I'm just
all right, Mr. Crawford, ask your question, please.
I don't know what to make of this. I'm just a simple country attorney trying to bang out a living here in the Midwest. I don't know what he's talking about.
How do I go about getting a Supreme Federal Court here to pay for that record before I leave here?
You want to start with the Hague, sir. Just get right up there first, and then work your way down.
Because that's affecting my assistance to get me in trouble in America.
I don't know. I can't answer that question for you, but I say you would start calling a federal entity if you're asking for a Supreme Court document. Start with the federal courts.
So like FBI would work, or?
I don't know. I don't know exactly what you're asking for. So I would start maybe there and then work backwards and see where they tell you to go.
Can the guards help me with that with permission, or?
What's that?
Can the guards help me contact the Supreme Federal Court?
Oh yeah. The guards are all connected with the Supreme Court. They know they got the secret handshake and the password. No problem. And any guard in any lockup anywhere can pretty much hook you up immediately with the Supreme Court. Yes, go with that instinct.
Like court date.
Yeah, I don't know who you would contact. I mean, you're talking federal, so I would start with some federal entity to be able to answer your questions for you.
Like 16 states, 3-4 counties, not showing to court and stuff on accident because of like the resources won't give me information, and then the domination, like manipulation by gang activity, and
I heard you before. So just what I would suggest you do is start at a federal entity, contact a federal entity, and see if they can direct you to the proper place. Okay. Do you have any questions? Huh?
Is an address for that or a number?
Information, sir. So when you're released, you might be able to use a phone book or try to research that to find out. I don't have that available to me.
Okay, it's called
And you also have an attorney. So Mr. Tyler Allen is still your attorney, so you might be able to consult with him to see if he can give you assistance on that.
Yeah, I will call him if they'll let me. That's cool.
Okay. All right, sir. Do you have any other questions?
No, Your Honor, I do not. And God bless. Thank you.
You bet.
I have a question. It won't be my usual question. It won't be my usual question. I know that 99% of the times when I say I have a question, well, it's one specific question, but that's not the question I'm going to ask here. The question I'm going to ask here is why the hell? Well, I don't know that we haven't, but I guess the first question is, have we done a competency evaluation? And my second question is, if not, why haven't we ordered a competency evaluation? I have the overwhelming sense that this guy's not competent. And the judge or magistrate or whatever, when he starts in with his Supreme Court theory, says, you know, he says something quasi-reasonable. It's reasonable in the sense that it's correct, but it's insane in the sense that it presumes the premise of the question wasn't insane. He's like, well, you might want to start in federal court because, you know, if you're talking about the U.S. Supreme Court, you know, you start in that system and then that's the top of that one. You know, like you don't want to start in the state courts if you're trying to hook up with the Supreme Court. Okay, that's true as far as it goes. I'm with you, magistrate. How about, have you been evaluated for competency? That's a more appropriate response to that question. I get it. He's like, I'll just say this. Maybe he'll forget. No. He follows up. Oh, that's great. Can the guards hook me up with that with with the federal system? No, they can't. You're currently in the state system. I don't know. Maybe their neighbor works for the federal system. I doubt it. But no, and he's asking this because he's asking this for one reason, which is rational. He's like, can the guards help me? The answer is no. But why is he asking, can the guards help me? Because they are the only other human beings he has access to. Oh, you know, it could help you. You know, they have this group of people that do this law talking thing. I forget what they call them, but they go around and they help people law talk. When people have issues in court, federal and state, hell, even the Hague, they talk to this class of people, and they rub their chins and they think about things, and then they give advice. You should probably talk to one of those. Probably talk to one of those people. Just saying. But what do I know? Thank you for coming out. I appreciate it.